Good morning, everyone, and welcome to the Beasley Allen webinar series. On today's program, you'll receive the latest details on Camp Lejeune water contamination claims. My name is David Byrne, and it's my pleasure to introduce our panel of speakers for this very important litigation topic. Today, Beasley Allen attorneys Matt Pettit, Julia Merritt, Trisha Green, Elizabeth Weyerman, and Leslie LaMacchia will provide an overview of the Camp Lejeune Justice Act. They're going to talk to you about the Act's benefits and eligibility requirements, and they'll address the things that you should be looking for when you're screening cases and as you approach this important litigation. Before I turn the program over to our speakers, and while we're waiting on the last of our registrants to join us, let's go over a few CLE housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order for you to receive full credit for attending, you must stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you'll receive another email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded. And for those of you who are Alabama and Georgia attorneys and you're participating by phone, that's important. If you're participating by phone from Alabama or Georgia, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com to ensure that you receive full CLE credit. Also, be sure to check out the events page of our website. It's located at beasleyallen.com/events. We're going to be adding more webinars throughout the year. For the month of October, Dee Miles, Lance Gould, Leon Hampton, and Rebecca Gilliland will share their thoughts on spotting fraud and consumer litigation cases. That program is scheduled for Wednesday, October 19th at 11 a.m. Central, noon Eastern. So go ahead and register now, folks. Finally, if you have questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, Matt, Julia, Trisha, Elizabeth, and Leslie, let's get started.
Thanks, David. First of all, thank all of y'all for taking time out of your day to attend this webinar. We hope that this information will assist you in litigating these cases. And so once again, my name is Matt Pettit. Today, I'm going to be covering the Act itself. Camp Lejeune is part of a larger act honoring our PACT Act. It was passed on August 10th, 2022, and that's a very important date because that's going to be the date that is used to determine the new statute of limitations and statute of repose for this act itself. The full text is available at this link in the slide if you'd like to see it for yourself. And specifically, the Camp Lejeune Justice Act portion is Section 804. So if you could go to the next slide. So this is a unique statute that is a little bit different than other litigation that's going on currently. For starters, the exclusive jurisdiction is in the Eastern District of North Carolina, but it's important to note that this is not a multi-district litigation. So the JPML consolidation rules are not at play. The Eastern District of North Carolina also has some very specific filing instructions on their website. So prior to filing any kind of civil action, you're going to need to familiarize yourself with those rules. Like I mentioned on the first slide, the filing period is 2 years from the enactment of the act itself, that August 10th, 2022 date. And another kind of distinguishing aspect is the burden of proof. The burden of proof in this action is lower than what's generally used in civil litigation, that preponderance of the evidence. Preponderance of the evidence requires that it's greater than 50%. And for this act, the standard is it's as likely as not, which that allows for proof that is at least 50%. So you can kind of see that distinction, which is going to be critical for some of these cases. So the statute itself imposes its own statute of limitations and statute of repose that will supersede North Carolina's standard statute of limitations and statute of repose. And this also extends to death cases as well. And so for death cases, even if a decedent has passed away decades ago, that is still a viable claim. So what we're recommending is if the estate is already open for a recent decedent, don't close it. But if the estate has been closed, maybe look into reopening that. We are waiting to see some indication from the court system itself for how they're going to handle that. But at the moment, nothing concrete has been established. So a prerequisite to filing a civil action under this federal statute is that an administrative claims file must be processed or submitted. We're going to go into more detail about that in a bit, but generally speaking, it's important to know that the administrative claim that is filed is not filed under the Federal Tort Claims Act. The admin claim for the purposes of this act serves merely as notice to the government. And you're going to want to make sure that you pay special attention to how these are being filed so you avoid the Federal Tort Claims Act. Also, the act limits the government's defenses. I've already mentioned the adjusted statute of limitation and statute of repose, but also the act removes the immunity defense and the Fairness doctrine from the government's arsenal. I believe most people are well familiar with immunity, but for those who don't know the Fairness doctrine, it's a defense that prevents members of the armed forces who are injured while on active duty from successfully suing the federal government under the Federal Tort Claims Act. And like we said, since this is separate and apart from the Federal Tort Claims Act, that defense is not going to be at play. Another unique aspect of this act is the funding. The Camp Lejeune Justice Act is funded by the Judgment Fund, and this is a permanent, indefinite appropriation that is available to pay monetary rewards against the United States that are judicially or administratively ordered. And one of the last most kind of important parts is that the act does not allow recovery of punitive damages. It is only for compensatory damages. And so that's why it's going to be incredibly important in these cases to get to know your clients, get to know their stories, and to be able to think of creative ways to present their damages to try to maximize what they should be able to get. And as far as the act, that's some of the major points that distinguishes it from other civil litigation. So at this point, I'm going to let Julia speak about the Camp Lejeune and the contamination history.
Hey, thank you, Matt. I am Julia Merritt, and I'm going to be talking a little bit about contamination history at Camp Lejeune, the chemicals at issue, and some of the proof that's needed to prove your claim. So there were 3 separate groundwater sources at Camp Lejeune that were contaminated, and those are Had Not Point, Tarawa Terrace, and Holcomb Boulevard. So Had Not Point treatment plant provided drinking water to the main portion of the base at Camp Lejeune. So most barracks and workplaces were provided, the water came from Had Not Point. And samples were taken of the water at Had Not Point beginning in 1982. So I'd like to just give you a little preview of the levels of contamination here. The maximum contaminant level for one chemical at issue, TCE, is 5 parts per billion. But back in 1982, samples were found as high as 1,400 parts per billion. Again, the maximum contaminant level for PCE is 5 parts per billion, but samples were taken back in the 80s and were found at 100 parts per billion at Had Not Point. And the other chemicals that were found are vinyl chloride and benzene. Now, a different water treatment area was Tarawa Terrace. That treatment plant provided drinking water to Tarawa Terrace housing area at the base. And their PCE was measured as high as 215 parts per billion. So after these samples were taken in 1982, they did a historical reconstruction, a modeling of the drinking water to figure out when this contamination started. And the historical construction modeling found that the chemicals were likely present as early as the 1950s. So what we know now from these reports is that the government knew as late as 1982 when these samples started, being taken, maybe earlier, but did nothing until shutting down some of these wells in 1985. This then became a EPA Superfund cleanup site in 1989. So if you think about what was happening at Camp Lejeune during this time, Marines are in active training, and they are likely to drink 6 liters of water per day on training days, 3 days a week, and 3 liters of water per day on other days. And a lot of our Marines were complaining that this water tasted funny, something was weird about it. And leadership at the camp said, oh, don't worry about it. These are minerals from the North Carolina mountains, and you should drink more. It's good for you. So the level of either deception or ineptitude here is really high, and the level of toxicity is also really high. So I'm going to introduce a document to you here. Elizabeth, you can switch to the next slide. This is a document. I'm holding it up here, and I'm going to show you the next one. Yep, that's good. It's the Atsdr. That stands for the Agency for Toxic Substances and Disease Registry. They have a very helpful website. I encourage you all to just check it out. There's a lot of history on Camp Lejeune. It's atsdr.cdc.gov, and that's where you can find this report. This report is dated January 13th, 2017, and it is called The Assessment of the Evidence for the Drinking Water Contaminants at Camp Lejeune and Specific Cancers and Other Diseases. And I'll tell you, this is basically our playbook for litigation. It lays out the epi studies. It lays out the levels of contamination. It is 147 pages, I believe, and it has charts and graphs. So there are a lot of injuries at issue here. And as you've probably heard, there were over 1 million people who resided at Camp Lejeune, resided or visited or were exposed to the toxic water at Camp Lejeune between the requisite time period, which is August 1st, 1953 through December 31st, 1987. So we're dealing with, at least 5 chemicals here that I've already listed out. We've got TCE, PCE, benzene, DCE, and vinyl chloride at extraordinarily high levels. So we've got a lot of potential injuries at issue. The Atsdr lays out some injuries that there is a presumptive level of causation. Now, different firms are doing different tiering of the injuries. And I'm just going to say one way of tiering these injuries is to look at the Atsdr and figure out where there is presumptive causation. And I'm just going to read the classification scheme categories that are listed in the Atsdr. One of those is sufficient evidence for causation. So if you have a client who was present at Camp Lejeune during the requisite years for 30 days or more, and their injury is listed as sufficient evidence for causation, there's your proof. There are other types of causation. There's equipoise and above evidence for causation, and then there's below equipoise. So what I'm going to focus on now is sufficient evidence for causation. And those illnesses and injuries are listed as bladder cancer, non-Hodgkin's lymphoma, multiple myeloma, leukemias, different kinds of leukemias, liver cancer, Parkinson's disease, kidney disease, and scleroderma. So that is one level of injuries, the highest level of injuries that we have, our tier 1 injuries. There are many other injuries, including cardiac birth defects, miscarriages, neurological disorders, and that could be considered tier 2, and some more obscure injuries might be considered tier 3. So in order to prove your case for those tier 2 and tier 3 injuries, you have to kind of recreate where your client was at Camp Lejeune and during which year and what chemical they were exposed to. So not all of these chemicals cause all of these diseases. So that's where expert work comes in. That's where good lawyering comes in, creating timelines, understanding maps, and figuring out whether your client was in the right place at the right time, or the wrong place at the wrong time, more accurately, to be able to be compensated under this statute. So I'm going to pass you over to Trisha now, who is one of our intake attorneys, and she's going to tell you how the intake process really works.
Thank you, Julia. I'm Trisha Green. I oversee a lot of the intake, especially for this project. So I was just going to kind of give you guys an update on what intake is like now. It's a lot. There are estimates that up to 1 million people were exposed to the water at Camp Lejeune. There are other estimates that are a little bit lower as well, but either way you cut it, there were a lot of Marines and their families that went through that base over this 30-year span in question. Not all those people sustained an injury related to the exposure, but a lot did. And those exposed, either with or without an injury, have a lot of questions, and you and your staff need to be ready to answer those questions. So I think it's really important to have a plan. Determine which of these calls and leads are legitimate quality cases. It's important to do your due diligence and confirm that the injuries that the client is reporting to you are accurate. You can't be filing cases that are false. So before you're filing, make sure that you've confirmed that that is the actual diagnosis. It's not unusual that a client doesn't understand their diagnosis. So it's not that they're trying to trick you, but doctors, like attorneys, have their own weird language that everyone else doesn't speak. So make sure you've really confirmed that what they're telling you is accurate, and also that you haven't missed anything. Sometimes we'll tell you that they have kidney disease, but they mean kidney cancer. So definitely make sure you dot your I's and cross your T's. And make sure you have that plan in place, how you're going to do this before you file the administrative claim, and be thinking ahead to how you're going to handle and what you need to file that civil suit as well on the front end. I really encourage you to be thinking ahead, to use intake as a way to set up the foundation for your case. You also definitely need this information to determine if this is a qualifying suit. So the main criteria for these cases, Julia's already kind of mentioned it, that one of them is injury and the other is exposure. So I kind of think about it as checking 2 boxes at the intake stage. The first box is pretty laid out for you, and that is the exposure one. The statute tells you it has to be an individual or their legal representative who was exposed to the contaminated water for at least 30 days between August 1st, 1953, and December 31st, 1987. Pretty straightforward. Obviously, as lawyers, we know that weird situations always come up, but this is the easier, more straightforward one. Second box is a little trickier, as Julia mentioned. There needs to be an injury related to the exposure, but what does that mean, and what do you do? What do you plan to do to prove that? So you have your presumptive injuries that have been mentioned, and then you have kind of everything else, and you need to have a plan for how you're going to handle both of these and what you're going to collect. As we mentioned, the presumptive injuries are kind of laid out there. They're listed in the Atsdr, and that's what most people refer to as the tier 1 cases. Some have expanded that a little bit. I don't think that those are going to necessarily be slam dunk cases. You're not just going to file a form and get money in return from the government. I would love to be wrong about this, but I am probably not. So make sure you manage your and your client's expectations accordingly. I think people see their name on, or their injury on that list, and the bar can be set in a little different spot than it needs to be. So make sure all along the way you're kind of conveying this to clients, that it's still a process. You're not just filling out this admin form and getting a check in return. The other category is that literally anything else. So make sure you have a plan in place to decide which injuries your office is going to lump into this category. Which ones do you think you would be able to prove some sort of causal link for? Just because the government doesn't acknowledge that the causation exists, it doesn't mean that the link isn't there. So when you hear multiple clients call and tell you that they have some really rare disease and they were all at Camp Lejeune, that's probably significant. You should be paying attention to those trends, and so should your staff. So make sure they're aware as well. When you're forming your plan for what kind of questions to ask during intake, a good place to start is that administrative claim form that Elizabeth's going to tell you about in a little bit, not quite yet though. And explain to your client why you're asking these really specific questions, because they're going to want to know. Explain them how the process works. Explain that there's an administrative process that has to be completed before the civil suit. Explain that there's a 6-month time period in which the government has to make a decision. So that's a lot of lag time where it doesn't look like anything's happening to the client because they're not seeing things filed. Also, please explain to them, if you are not personally keeping the case but referring it to Beasley Allen or another firm, how the referral process works. It's really awkward when I call a client and say, hello, I'm your lawyer. And they're like, no, you're not. You're calling from Alabama. I hired this person in Jacksonville who I know and trust. So if you could please just give them a heads up that you have co-counsel, that somebody's going to be contacting them. Generally, this is a group of client who's been poisoned by their own government, so there might be some trust issues. So please don't set me up for failure. Just give them a heads up that I'm going to be calling and asking invasive questions. So have a plan and manage expectations are very important, and don't surprise them. When it comes to the documents, you need to really think ahead and get everything you can on the front end. And those 2 different boxes require 2 different types of documents. So you need to have a plan for what you're going to need to prove exposure and what you're going to need to prove the injury. So for the injury, make sure that you have forms to cover both private and VA hospital providers. Some clients have utilized both. Some clients have multiple injuries, so you need to make sure that you are confirming each of them so that you've done your due diligence. You need to also make sure that you have documents to prove the exposure. If they're a Marine, get that DD 214. They probably already have it. If they aren't military, ask them what they have. A lot of people held on to things. Pictures of them on the base. Some people have put together their actual address just from old pictures. School records. Did somebody send them a postcard while they were there? Tell them to get creative. A lot of them have held on to stuff, but they don't want to bother you, so you need to prompt them. I asked one client to bring in something, or just say, give me what you have, and he brought in a tabbed binder for his deceased brother from his elementary school records all the way to the death certificate. So some of these people are very organized and have really held on to stuff. You just have to ask them. And that goes back to knowing your client base. Chat with some of these people, learn where they were, what they were doing on the camp, after the camp, before the camp, all of that is going to become important later. And I think that at the intake stage is where you're going to build the foundation of your cases. So use that. It's not just signing a client up. It's welcoming them in and getting to know what's going on with them. And you're going to be able to see those patterns in all these cases. So the main thing, if you take anything away from this, is just be prepared and manage expectations. And if you ever have questions about intake in general, feel free to reach out to me. But now we are going to go to Elizabeth, who will tell you more about that admin claim process.
Yes, and before you are able to file any admin claims, the Navy requests that you file and email them one law firm registration per law firm. So we are going to attach this in the email with the slides, but you are going to fill this out, save it as a PDF, and email that with the subject line completed registration form to this clclaims@us.navy.mil. And that's going to be the same email address that you also submit your admin claims to. If you see in this top right section with the legal technologist, if you fill that out for your firm, then the Navy will contact that technologist with any technology questions that they have about your firm before they contact the individual attorneys that you list at the bottom. If you ever need to modify this form, if you have new attorneys joining or some leaving, then you'll refill out the firm information at the top, and on the left column where it says action, you'll select modify, and then you will re-email this form to the CL Claims email address. Right now, there's 3 different options for filing the administrative claims. There's filing individually with the form that you see on the right side. There's mailing CD-ROMs, or the third options are the CSVs that you see in this bottom left. That's a comma separated value file type. The first option, filing claim forms individually. Just to be very clear, Matt mentioned this earlier, that this is different than the FTCA. It's different than the standard 95 form. So make sure that you are downloading the correct form, which you can find at that second link. There's very detailed instructions with the first link about how to fill this out. But I want to be clear that it is a complicated process, and you need all of the intake information that Trisha just mentioned to fill this out. You have the option of either mailing it to the address that's listed, or emailing it by saving that form as a PDF with the last name of the claimant, comma, first name, and the date of submission, which is the date that you signed the form. If you have authorizations for agents for your claimants, then you're going to save it as the second bullet point, which is that auth for claimant last name. And then you would email that to the same email address with the subject line. Make sure that in your email that you're including the authorizations and the individual claimant forms. Now, if you are filing 2 or more, the Navy wants you to do that by CD-ROM or CSV. This allows them to pull that data and put it in their own system. So to burn a CD-ROM, you need to include 2 folders, one labeled claim forms with those individual claim forms, and the other labeled authorizations. You're also going to mail them a cover letter with your CD-ROM. That's going to list how many claim forms and authorizations that are saved on that CD-ROM to that same address. Now, this third option for the CSVs, you saw that file in the first slide that looks like a green Excel spreadsheet. This form is going to be that cover letter that you mail in with the CD-ROMs or you email in with the CSV. So this shows you more detailed. It includes the unique ID that your firm creates for each claimant, their name, and the number that they're saved on as the CSV or in the CD-ROM. You're going to email that to the same email address with the subject line batch filing, and you're going to attach the CSV saved as a PDF and this cover letter saved as a PDF. Just to be clear, this has taken a lot of communication, steady communication with the Navy for us to understand how to do this. And it's still a work in progress. We've been told that right now, these are your 3 options to email these in or mail them in, but that they are creating a filing system online, hopefully within the next 9 weeks. We really hope that that happens, because we've been told that when it's made, we should have automated updates about what they've received. We have been told that the receipt, the 6-month grace period that they have to review each file, begins when they receive your email. So you might want to consider having an automated response when they open your email. If you have any questions about technology, or if you have attorneys change with who's handling these claims, email Jennifer Langley-Carnes. She's been a great contact for us. She usually responds pretty rapidly. Make sure the subject line of your email is CLJA IT issue, and that should help her know where to handle it. Of course, if you have any questions, feel free to reach out to me. And now I'm going to pass it over to Leslie, who's going to tell you about some claimant concerns.
Good afternoon. My name is Leslie LaMacchia, and I'm going to be talking to you today about current issues that some claimants are having and asking us about. So one is, why can't I handle this myself? We have to explain to them that the process is quite detailed. There are specific instructions, as Elizabeth just went over, and it has to be completed correctly. The claim form does, or else it will be rejected. They also have to understand that after the filing of the claim form, that a civil lawsuit can be filed on their behalf 6 months later. And in addition to that, you have to be able to provide your proof of presumptive diagnosis, the proof of your service dates, and proof of location. So these are all things that an attorney can handle for the claimant as opposed to the claimant handling it themselves. We're getting a lot of questions also as to whether or not the VA benefits will be affected if they file a claim. The answer to that is no. This is additional compensation. The Camp Lejeune Justice Act is the exclusive remedy for these Marines and their family members. There's one small caveat to this, is that if the VA, for example, has determined that their VA benefits were due to the exposure of Agent Orange, their benefits could be affected, but otherwise the VA benefits will not be affected by the filing of this claim. What if I'm receiving medical costs covered by the family member program that should be the Family Act of 2012? The answer to that is it's okay. The Family Act of 2012 provided health care to those on active duty and reimbursement of medical care to eligible family members for 15 specific conditions, but the Camp Lejeune Justice Act will provide monetary compensation for 40 health issues. So if they're still receiving medical costs covered by the Family Act of 2012, it's completely okay. How much will I get? We're getting this a lot as well. So under the judgment fund, as Matt previously discussed, there is healthcare and compensation being provided to these claimants, but the government's not going to pay forever, but the fund is expected to be up to $6.7 billion, and there could be hundreds of thousands of claimants. So I can never give them an answer of what they're going to get, but I can give them some sort of idea of what the fund should provide to them. The timeline for the process, as Elizabeth touched upon, we're able to explain to the claimants that we first have to submit a notice of claim with the Navy JAG. Then it will be reviewed by the government. And then after the review of that, it's an estimated 6 months for us to then file a civil lawsuit on the claimant's behalf. So it is a process. Is this a class action? No. After the claims process, each of these claimants claims will be prosecuted as an individual lawsuit in the Eastern District of North Carolina. The Eastern District of North Carolina will be the exclusive jurisdiction, and each claimant will have a right to trial by jury. So it's very important to explain to your claimants that it is not a class action. So in terms of what is going on right now with the Camp Lejeune litigation, the status of the claims process is still being ironed out with regards to the filing and the submission details, as Elizabeth explained. We're in constant communication with the Navy JAG, and we're ironing out everything. So as soon as that process is ironed out, I think the litigation will move forward at a more rapid pace. But both of us, the government and the plaintiff's lawyers, are basically starting from ground zero on this. Legacy cases, these were cases that were filed as civil cases in North Carolina on day one of the passage of the act. The government has told filers that they do plan on filing motions to dismiss, but that has not yet happened. But we assume that it is going to be happening soon. The status of the government evaluating the claims, administrative claims were denied before the act was passed. So the government really never had a chance to evaluate them and properly assess any of the claims to date. So like I said before, the government and us lawyers, we're all starting this together. Matt is going to answer a couple of the updates as to the motion to consolidate.
Yeah, thank you, Leslie. So there, like she said, there have been some what we're calling legacy cases that were filed in the Eastern District of North Carolina the day that the act passed. These complaints were based off of administrative claim filings that had been done prior to the passage of the act. And these are pending before a couple of the judges right now. And the judges who have ruled on this motion to consolidate have denied the motions at the moment. There are still some pending motions before some of the other judges, but at least two at the moment have denied these motions. And then also touching on the class action, there is a class action complaint filed in the Eastern District of North Carolina, but no action has been taken in that case for any kind of class considerations.
So what's next? If you are attending this webinar, I'm assuming you've either started to evaluate your claims, but I wanted to let you know Beasley Allen is handling all of these in-house. So if you're considering being a referral attorney, we are handling them in-house. We've been in constant communications with the proper authority about the process and trying to make it as seamless and easy as possible. And if you have any questions about the process, or you're unfamiliar with the volume of cases like this, or how to handle the volume of cases, we're very happy to help you with this.
All right, thank you very much. On behalf of all our viewers, I want to thank our entire panel, Matt, Julia, Trisha, Elizabeth, and Leslie. We really appreciate you bringing us a very thoughtful and thorough presentation. We've received a number of questions during your talk, and if you'll allow me, I'd like to present those to you one at a time and try to get the panel's feedback. So panel, our first question comes from James, who asks, are there specific funds appropriated for the Camp Lejeune Act?
I can take this one. So there is not a super fund created for this, but it's actually even better. To be honest, it's better for the clients. The Congressional Budget Office has issued, an estimated budget, and you can look on cbo.gov and find the exact budget. But so the nice thing about it is it's estimated and it can change over time. It can be increased. So I would encourage you to really dig into that document. It's pretty complicated, a lot of footnotes, and it's an interesting way to do it. So.
Yeah, and just adding off of that, it's funded by that judgment fund. And so this won't be a race to the bottom to try to get yours funded before others. So that is an amount that can be, and most likely will be, replenished and will reflect the state of the litigation and not an arbitrary number.
All right, our next question comes from David, who asks, is there a central location from which you're requesting the military medical records, service records, or VA records?
Yeah,
So,
yeah.
We give them a form to help them request the DD-214, but there's also an online portal they can use. Most of them already have it. So yes, but there's multiple ways to get it.
Our next question comes from Jessica, who asks, could you please elaborate on how and why VA benefits for Agent Orange exposure would be impacted by a Camp Lejeune administrative claim filing?
Sure. I'm not saying that it necessarily will be affected. I'm saying it's possible that it could be affected if the VA has determined that your benefits that you're receiving were due to the exposure of Agent Orange. So it's something you just want to be very careful of. And if these claimants are worried that their benefits are going to be affected, it's something you do want to walk through it with them.
And I would just like to add to that, there is a set-off provision in the Camp Lejeune Justice Act. So I try to think of the VA benefits and the Camp Lejeune Justice Act as kind of two different pots, two different ways to obtain monetary relief and benefits. And the government isn't going to allow for double collection. So if you're receiving VA benefits for Camp Lejeune water contamination, and then you obtain benefits from under the VA, and then you obtain benefits under the Camp Lejeune Justice Act, there may be some sort of a set off. We don't know what it will be yet, obviously, but that is a potential.
All right, thank you, panel. Our next question comes from Paul. Paul asks, will any claims be settled administratively, or do they all go to court?
So there's some, I can take a first stab at that, and my colleagues can chime in if they have more to add. There's been a lot of speculation about that. You know, a lot of this bill is unknown to a certain degree. We have heard both sides that at the administrative claims level, the government is going to engage in non-nominal offers for at least a particular subset of injuries, you know, those presumptive injuries. And then, you know, on the other side, we've heard that this is going to fall on deaf ears, and it's going to be something that's really figured out in litigation. So at this moment, it's something that is currently developing, and I think we'll get a better picture on it once some of these 6-month time periods begin to draw close on the submission of those administrative claims.
And
Matt?
I would like to add to that, the government has specifically requested that we do not send medical documents and proof with the administrative claim. So I think that's a little hint, if we're not sending any proof, that they're not going to be paying these out until they're able to, you know, analyze and prove the claims.
Good point. Good point. So our next question comes from Ronald. Ronald asks, are the attorney's fees limited to 25% as they are under the Federal Tort Claim Act?
They are not. Like we've discussed, this is completely separate from the Federal Tort Claim Act. And, you know, unless and until there is some kind of court intervention, any kind of fees that are dictated by the FTCA won't be applicable to the Camp Lejeune Justice Act.
And I'd like to add to that, you know, my colleagues and I have been to seminars across the country from, you know, various law firms, and it is the consensus that 40% is a reasonable fee for these cases. Don't be afraid to ask for 40%. We're doing a lot of work. We have to do a lot of expert work, a lot of legal work on these, and don't limit yourself to 25%.
One of our viewers, Florence, asks a related question. She wants to know, how worried or not worried are you about the churning at Congress regarding canceling the legislation potentially due to attorneys' fees ranging at 40% levels, and in some cases higher? Anyone want to take a stab at that? Is there a threat of Congress cutting back on this legislation because of attorneys' fees exceeding FTCA levels?
I mean, obviously we can't predict the future. However, this act went through without amendment. So it was passed by the House and the Senate and signed by the president as is. And it specifically, there is a portion of the act that specifically carves out a segment stating that this is not the Federal Tort Claims Act. And we have a completely different way of filing the claims. If you filed a claim under the Federal Tort Claims Act, it does not count. You have to file it under the Camp Lejeune Justice Act. So, you know, I mean, I think I personally feel comfortable with 40%. Because I think it's a legitimate amount for a personal injury claim. That's not a Federal Tort Claims Act, but, you know, like I said, you can't predict the future.
And am I correct, panel, that the act does not prescribe the attorney's fee percentage in any way?
Correct.
Okay. One of our viewers, Chase, asked the question, are the monies in the judgment fund parsed out on a first come, first served basis?
No, it won't be kind of that race to the bottom where there is a fund and you need to try to get your cases in there as quickly as possible to get as much money as possible. As discussed, the judgment fund is a fund that can be replenished and is not subject to congressional oversight for approving it. And so because of that, the funding for this litigation, there has been an initial amount put aside or budgeted, but that amount won't be the only amount.
I think Matt is muted. Did you finish your answer, Matt?
Yes, I guess I didn't know when I pressed the mute, but long story short, no, it won't be first come, first serve. It's a fund that can be replenished, and there is a preliminary amount appropriated to it, but more will come if there is a need for it.
All right, thanks very much. Good question from Brad Ponder. He asks, are you opening an estate for each of the deceased claimants prior to filing an administrative claim, or are you using other documents to prove the representative is in fact the next of kin?
I can take this one. So the important thing is that your client actually has standing to bring a claim for the deceased relative. So during the intake process, I assure you that you're going to receive a lot of calls from people who, oh, this was like my grandfather, this is my cousin, so our position is that we are not filing administrative claims for a death case without an administrative estate being set up. I don't know if that's universal, but that's what Beasley Allen's stance is going to be, because we need to have somebody who the check can be written out to in the end, and it needs to be a person with legal standing to bring the claim. Also, after the administrative claim process goes through in 6 months, we need to file suit and we need to have a proper plaintiff. So we like to do the work on the front end and get the estate. I'll also mention, just because we're talking about estates, that these claims need to be brought in the Eastern District of North Carolina after the administrative claims process has gone through, and North Carolina requires an ancillary estate. So you might have to set up 2 estates. So just be aware of that.
David,
David,
I think you're muted.
Still muted, David.
Guys, I'm so sorry. Sorry for the technical problems. Okay, panel. We have a question from Brenda, who asks, what about an affected recently deceased wife whose spouse was affected while stationed at Camp Lejeune? Can the surviving spouse, a former Marine, or an heir file?
So I think it's going to vary state to state. I know I've talked to some people in other states who tell me that is what they would do if they were filing in state X. So I think it's going to be a case-by-case basis. So when that happens, if you're referring them to us or whoever, just make sure you look into that a little closer. I think it's just going to be I need more facts to decide.
Ask the panel this question. So the claim form requires a claimant to list an amount that they'll accept for their claim. Is there any downside to listing a large amount? How will the amount affect the timing and the resolution of a submitted claim, if at all?
I can take this one. So the important thing to know about the amount that you file or list on the administrative claim form is that it acts as a ceiling. So if, for example, and once you take a case to verdict at trial. So if you were to state that your wrongful death case was worth, I'm making up a number, $100,000 on the administrative claim form, and then you were to take the case to trial and get a verdict of $250,000, then you're leaving $150,000 on the table. So aim high, but be reasonable. That's what I would say.
Okay. For cases involving miscarriages, do you know if the military has the medical records of the spouses as far back as the 1950s?
Sometimes they do. I know that there was a central repository where a lot of these records were held and there was a fire or a flood. So sometimes they don't. Again, ask your clients what they have. I have a Marine who has a letter they sent him when his wife miscarried that says, hey, baby X passed away. It's just very straightforward and cold. It says that exactly that. So again, it's one of those situations where they might have it. And if they don't, see what your client still has, because a lot of those Marines held onto the letters and they sent them to the Marines and not the spouses. So that might help your case.
And I'd just like to add something to that, something that Trisha has kind of talked to me about during the intake process is dealing with miscarriages is special. It's a different form of loss. A lot of, just take it with a level of sensitivity. It's hard filling out forms about something that happened so long ago. It's so painful. And also a lot of the forms aren't necessarily geared toward a military spouse who had a miscarriage. A lot of the forms are geared toward a military personnel who was at Camp Lejeune and has some sort of cancer. So it may seem, cold and heartless, and it's hard to handle. So I just take special care with your miscarriage clients.
Very good advice. We have a question from Chauncey. Chauncey asked, I have a former client who lost his parents. My firm is not interested in these types of lawsuits. What do you recommend that someone like that do if they're interested in speaking with other firms about possibly taking on those cases?
Like I said, towards the end, I think the PowerPoint shows all of our email addresses, and we're more than happy to discuss with you the referral of any cases and discuss the facts of the case with you.
Yeah, and I'll jump in. Definitely email me, especially if you have a question of maybe this person qualifies, maybe they don't. It's such a short window. I would love to find any way I can to consider any case. So you're not wasting anyone's time. It is not a problem. Definitely email me if you need an intake packet. I'm your person. So yeah, my email address is there. Let me know if you're thinking about it or if you want to talk about potential cases. Happy to do that anytime.
So panel, we have a great estate-related question from Vanessa. Vanessa asked, can we get a little more clarification on the estate consideration? So certain states, like Missouri, don't require an estate for a wrongful death claim or the associated survival claim. And it seems that consistent with Missouri law, a surviving spouse of an injured Missouri resident could sign the contract to pursue the administrative claim. If the case then proceeds to litigation in North Carolina, will North Carolina then require an ancillary estate in that wrongful death case, even though it wasn't required under Missouri law? Anyone want to take a stab at that?
I think the way it looks right now, yes, that's likely. And that's why I say we got to do this on a state by state basis. But I think at some point, North Carolina is going to get overwhelmed with just the very large amount of these cases being filed. So I'm hesitant to commit to, yes, you definitely have to, because I don't know that that will always be the case. So definitely when those come up, we're really going to have to, I don't want to make somebody open an estate if you don't have to, but North Carolina might make us, at least where we're at right now. But it's possible that could change, and hopefully on the next update, I can give you more information about that. But right now it's really gray, unless anybody else has more to add to that.
Well, and would it be fair to say, Trisha, that a lot will depend on what the managing judge or MDL judge elects to do? I mean, oftentimes in these mass cases, it's those judges who consolidated the litigation, who are handling all of the pretrial proceedings. They come up with shortcuts to try and help with that sort of thing. Is that been your experience?
Absolutely. Yeah. And I think because we have this this kind of slowdown with the administrative claim, it's kind of put a little lag here to where we can't really dive in and get into the meat of what this is really going to look like. So right now it's a lot of, I think you have to open one, but that's just because we haven't seen if one judge is going to handle these. Are these going to be consolidated? Are they going to make it to where there's a process for out-of-state attorneys, at least just for these death cases, because there's going to be quite a few? Is there going to be an expedited process? Because if not, we might break the North Carolina system, and we all want to avoid that. So hopefully things will get streamlined, but right now they're not.
Well, if you have to brave the North Carolina estate filing system, where do you anticipate that ancillary estate would have to be filed in North Carolina?
That's a good question.
Yeah, I mean, the location, the court location is the Eastern District of North Carolina. That's where the claim resides. I don't know. I mean, that's where Camp Lejeune is located. That's where the tort occurred, but that's up in the air still. I'm not sure.
I have another good question from Ronald. Ronald asked, what's the best resource to look at to try to determine the types of injuries that have been generally associated with exposure to that contaminated Camp Lejeune water? Are there specific epidemiological studies, tox studies, or anything else that someone like Ronald could use as a good source for information?
Sure, I can take that one. I'll tell you what, this document, the Atsdr Assessment of the Evidence, January 13, 2017, you can see it's thick. It is like kind of the Camp Lejeune Bible right now. So this is your best starting point. This is a compilation of epi studies and tox reports. So start there.
Nicholas asked, do you think direct filing will ever be an option, or is local counsel required? I think y'all have touched on that a few times, but let's take another stab at it. Do you think direct filings will be an option, or is local counsel required?
So I think this this kind of touches on a couple different areas. I know a lot of us multi-district litigation attorneys are very familiar with the direct filing procedures that most judges create in their litigations. But once again, you know, this isn't going to be a multi-district litigation. It's really going to be up to the judges to kind of decide how that process is going to take place. North Carolina does have some very stringent ethical rules that you need to be aware of, and they are very stringent with their practice of law, and to make sure that you are following those rules. I think at the end of the day, to some extent, you're absolutely going to need some kind of North Carolina attorney involved in your process, or someone who is at least barred in that state. So long story short, yes and no. You're just going to want to make sure that you're following what North Carolina is prescribing for their ethical rules.
All right, very good. Well, we have time for one more question. Again, for those of you who submitted questions, we appreciate it. If we didn't get to it, please feel free to reach out to any of the attorneys in our panel. They will be happy to answer any questions you have. You can reach them anytime by dialing our number 800-898-2034. They'll be happy to help you. We'll take one last question from John. John asks, do you anticipate that there will be a steering committee formed to work alongside or against the government to try and make the process more efficient in light of the voluminous number of claims.
So we kind of, you can go ahead, Julia.
We can all put our 2 cents in, the quick answer is we don't know yet. There are groups of law firms that are joining together, creating panels and things like that. It's just an unknown because this isn't an MDL and it's not a class action. We've got this 6-month administrative proceeding that we have to go through first. It's just an unknown.
Yeah, I think the only concrete thing that we can point to is that, motions to consolidate have been filed. And as of now, they've been denied. And so, it's kind of unclear what that court system is planning to do at the moment.
Okay. Well, thank you so much, panel. And for those of you who may have missed our earlier announcements, by the end of this week, you'll receive an email with a certificate of attendance and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys who are participating by phone today, please email us your name, your phone number, your state bar ID number. Send all of that to webinars@beasleyallen.com to ensure you receive full CLE credit. Also, be sure to check out the events page of our website, as we'll be adding more webinars throughout the year. Our next webinar is in October. It's going to be a great presentation from the folks in our fraud section. It should be very exciting. Go ahead, go online and register now. Thank you. Thank you, everyone, for joining us today. Thank you so much for supporting our Beasley Allen webinar series. We'll see you next time. Have a great day.